Following the pandemic, it is a fact that flexibility at work is prized more than ever. And come the 6th of June 2023, more people are going to be able to apply for it, and it is going to be harder for employees to refuse to grant it. Hi, I'm Jo Lilovich. I am the Director of 3D HR Legal and author of Homeforce. And today I am sharing with you our second update on the recent Fair Work Act changes. Today discussing the three major changes around flexible working arrangements. Of course, anyone at any time can walk up to their employer and say, I would really value some more flexibility at work in terms of my hours, my days of work, perhaps my location of work. And it will be up to that employer to sort of consider that. But only some of those people who walk in actually have a lawful right to make a request that requires a certain response to be made by an employer. And these requirements are enshrined in our Fair Work Act. So the people who can make this lawful request are people who have completed 12 months of service, and then they meet one of 5 conditions. The first one being they're either over 55, or they're a carer, or they have a disability, or they have the care and responsibility for a child of school age or younger, or they are someone who is experiencing domestic violence, or they are assisting a member of their family or immediate household who is a victim of domestic and family violence. As of the 6th of June, added to that list of 5 groups of people who can make these applications are also employees who are pregnant. So that's the first major change. The second major change is that it's going to be harder for employees to refuse when people make these requests. If they do want to refuse, they have to clearly set out their reasons for refusal, and they have to be based on reasonable business grounds. They must also have engaged in conversations with the employee and tried to reach an agreement and had consideration to the fact of, well, what does this mean if I say no? What is the consequence to the employee in this circumstance? When putting those reasons in writing, the employer also has to list out anything that the employer might be prepared to do that's perhaps not quite as much as what the employee was originally asking for. So that's the second major change, the extra detail that an employer has to go through before it can refuse a request. The third major change is the fact that now employees have a right of appeal effectively, and they can make an application to the Fair Work Commission to say, I've got a dispute with my employer because my employer has refused my flexible work request. And in that instance, the Fair Work Commission would review the request and make a determination about it. So to get ready for these changes, we recommend you do 2 things. First, you review your existing flex work policy. If you don't have one, consider whether this is the right time to implement one. And the second thing is make sure that all of your managers and your HR people are trained in these new provisions so that they understand that these sorts of requests have to be dealt with within certain parameters, and also that those answers have to be given within 21 days. It's also always very important to hit the time limits. So to find out more about this change and the other Fair Work changes, you can see our extended video series or read our detailed blog on our website at 3dhrlegal.com.au. And we also have a checklist there. So if you want our full list of recommendations on how to prepare for all of these changes, you can find them on the website too.